Well, welcome everybody to our first seminar, fantastic, of the Easter term here at the Center for English Legal History. We are extremely excited to be welcoming Ashley Hannay. Is it Hannay or Hannay? Hannay. Okay, you didn't.
I mean, it's an American accent, so
It doesn't help. So you didn't answer my question. Who is actually an ex-convener of the center himself and a little bit of a role model in my time here at the center for his successes. And he will be speaking to us today about the origins of the statute of uses. So without further ado, I will go ahead and turn it over. Thank you, Ashley.
Thank you very much, Doug, for both the kind invitation, and I think should be noted before I start, David, for your insistence that I think perhaps more accurately command that I came after learning that.
Who's your examiner?
Yeah, after learning that I was inadvertently attempting to answer one of last year's LLM questions on statute of enrolments. So here I am. As such, in this paper, I'm looking to explore and to explain the passage of both the Statute of Uses and the Statute of Enrolments in the Reformation Parliament 1529 to 1536. The importance of the Statute of Uses to the historical development of English trusts has been long recognised, and it should not be understated. Shortly after its enactment, the statute was considered by John Boys in his Gray's Inn reading, and was later subject to the famous readings of Edward Coke and Francis Bacon. The statute enacted radical reform of English land law, and it's from the embers of the statute's execution of uses to perform last wills that the doctrines of the modern trust emerged. Much of the focus of my broader work is on the legislation in the period before the statute of uses, particularly that of Richard III and Henry VII. Indeed, one of the central claims that I've advanced elsewhere has been the analytical benefit of moving away from a Whiggish view of the earlier statutes as simply being precursors to the inevitable statute of uses. By approaching this earlier legislation with a more critical eye and viewing them within their own contexts, a more complete understanding of the passage of the statute of uses is also possible. It is well known that from the mid-1520s, a campaign against uses, which affected the avoidance of feudal incidents, was underway. By 1529, the campaign's attention turned to legislative reform. And it is in the Reformation Parliament, as I said earlier, 1529 to 36, that Henry VIII proposed the most radical reform of English landholding since at least Quem Torres in 1290, and perhaps even the Conquest. These legislative proposals resulted in the final session of Parliament in the Statute of Uses and the Statute of Enrolments. In this paper, consideration is given to 6 earlier draft proposals, 4 of which were rejected, before turning to the final acts themselves. Understanding the evidence for the progress of the earlier drafts has not proved straightforward. Would you mind flipping over just to the first slide?
Yes.
The draft of the Statute of Uses there.
Yes.
Which makes my earlier worry fine because of the 5 there, not 4. So, with regards to, I'll talk through each on the slide in a moment. They're just merely there for signposting as I talk through them. But with regards to the evidence there, we know that in August 1531, Henry instructed Thomas Cromwell to prepare a bill of prima season to be presented in the 3rd session of the Parliament, which was 15th of January to the 28th of March, 1532. We also learn from Edward Hall, who was sitting in the Commons at the time, that on the 18th of March, 1532, Henry confronted the Commons, lamenting their lack of progress on his bill concerning wards and primal season, at which point the King also said that he had reached an agreement with the peers. It seems clear that this bill presented to the Commons in 1532 was the one reported as being drafted by Cromwell before. Further evidence emerged with the publication in the late 19th century of volumes 5 to 11 of the Letters and Papers of Henry VIII, which brought to the attention of legal historians a number of documents which are central to understanding the background to the statute of uses. Of these, 2 in particular have shaped our understanding of the passage of the statute. Firstly, the text of the draft bill, which can be dated to 1529, which is the first one on the PowerPoint. And secondly, an agreement between Henry and the peers, and a number of peers, on feudal incidents, primacies and wardship. The agreement with the peers must have been what Hall reported the king as relying on in his confrontation with the Commons in March 1532. However, understanding the draft bill has proved more troublesome. It is unlikely that the Letters and Papers draft bill, so on the top, was the one prepared by Cromwell in 1532. Rather, as we shall see, it is more probable that it was a separate earlier draft prepared in 1529. The 1529 draft began with a preamble in the dramatic style of the period, decrying the great trouble, vexation, and unquietness caused to the king's subjects by entails and uses, and the great dishonour done to Henry himself. The main provisions were radical. In a similar manner to the Statute 1 Richard III, Chapter 1, the draft centred on the uncertainty facing purchasers of land. First, the bill proposed the abolition of all entails, so that upon enactment, all lands, tenements, and other hereditaments would be held in fee simple. A later provision excluded the nobility from this abolition, but provided that any alienation by a nobleman must be licensed by the king. Second, that all uses would be invalid unless enrolled in the Court of Common Pleas. Third, immediately following the sale of any land, tenement, or other hereditament, the deed was to be read out in the parish or parishes in which the land lay, and was then to be registered with the shire town. In the shire town. The remaining provisions concerned limitation periods and were measures to simplify landholding more broadly. It was suggested by Plucknett that the 1529 draft bill was a provision designed to effect a degree of social engineering in reasserting the social and economic privileges of the nobility under the king. But as Bean has argued convincingly, considering the broader context, such an imaginative scheme seems unlikely. The proposed abolition of entails in the draft bill is perhaps better seen as being largely symbolic, the real focus of the bill being elsewhere. Following the decision in Taltaram's case in 1472, entails could be broken by common recovery, and it has been argued they no longer offered the secure settlement that they once did. Although the abolition of entails would have removed the need to effect a common recovery, and indeed the expense of doing so, it is unlikely that the concession to the peers was, as Bean has argued, intended as a sop to the pride of the nobility, as opposed to being of any tangible benefit. Indeed, the requirement for any subsequent entailments by nobles to be licensed gave the Crown significant control. It would be better to consider the draft bill as seeking to simplify landholding and institute a system of registered uses to administer family settlements. A textual analysis of the 1529 draft bill thus renders it very unlikely to have been the same as Cromwell's bill concerning wards and final season that was rejected in 1532. Returning to the agreement with the peers, ascertaining the connection, if any, between the 1529 draft bill and the agreement has proved difficult. The current orthodoxy, advanced by Bean and Holdsworth, among others, has essentially argued that the concession to the peers in the draft bill persuaded them to support Henry's efforts to limit the loss of feudal revenue through uses in his agreement with the peers. However, this position seems untenable. Whilst, as has been noted, there was some advantage to the peers in the provisions of the draft bill, it was likely to be of merely symbolic value. It's difficult to suggest that it was enough to justify a quid pro quo in relation to the incidents. Furthermore, a number of the signatories were very close to the king and were supportive of his broader causes in the Reformation Parliament, perhaps suggesting that they would have supported the draft bill even without the concession. Additionally, some of the signatories had only recently been elevated to the peerage, and Edward Stanley, Earl of Derby, sued his livery during the Parliament, both of which may have been conditional upon support for Henry's legislative reforms. An alternative explanation has been offered by Ives, who argued that the 1529 draft bill and the agreement with the peers were unrelated, as the draft bill, rather than being an official government proposal, was in fact written by a well-intentioned but inexperienced amateur. To support his position, Ives made two arguments. Firstly, that the impractical nature of several of the provisions particularly in relation to registration, suggests that it was ill-conceived and not an official proposal. And secondly, that the focus of the draft bill was on reform to landholding more generally, rather than being specifically aimed at the avoidance of incidents through uses. The first of Ives' arguments is not overly compelling. As he himself accepted, the fact that suggested legislation is ill-conceived does not, of course, establish that it was of unofficial origin. Indeed, earlier legislation on uses suffered from the same apparently ill-conceived nature, particularly the Statute 103, Chapter 1. Furthermore, that a radical proposal to completely overhaul an area as complicated as late medieval landholding would create technical and practical difficulties is not merely unsurprising, it was to be expected. The second limb of Ives' argument is more interesting. He argued that the draft bill was unlikely to be official, as its focus was broadly on the law of real property more broadly, and not specifically on the avoidance of feudal incidents. 2 points can be made in relation to this argument. Firstly, a broader focus on real property does not necessarily mean the draft bill was not official. If anything, considering uses within the broader context of the law of real property was again to be expected. Second, even if the bill was official, that does not necessarily mean that it was related to the agreement with the peers in the manner that Holdsworth and Bede suggested. Whilst it must be stressed that the avoidance of incidents was clearly important to the Crown's motivation in the Reformation Parliament, that does not necessarily mean that it was central to the Crown's legislative approach. An important document known as the Damna Usum, or Inconveniences for Sufferance of Uses, may be informative on this point. A list of mischiefs, wrongs, and inconveniences caused by uses, the authorship of the Damna Usum is unclear, but is most likely official and produced for Cromwell or those around him, as part of the negotiations which culminated in the Statute of Uses. It is notable for the lack of emphasis placed on feudal incidents. Of the 43 complaints, the loss of feudal incidents appears 39th. In this, the Damna Usum adopts a very similar approach to that of Audley in his 1526, Thomas Audley, in his 1526 Inner Temple reading, and of the anonymous author of the 1530 replication of a sergeant at the Laws of England, in downplaying the loss of incidents. As Professor Baker notes, this was likely a result of the need for the Crown to win over the Commons, independent of revenue concerns. Stronger protection of their titles from uncertainty may be what the Commons were offered in the 1529 draft bill, in support for their reform on the avoidance of incidents. However, there is perhaps a more compelling explanation for the draft bill. The argument put forward by Ives that the draft bill was amateur and not convincing. That being said, it is very plausible that it was official, but did not directly correspond to the agreement with the peers in the manner that has been suggested. The evidence connecting them is shaky at best. From the documents, 2 things are clear. That the 1529 draft bill contained an exemption for the peers in relation to entails, and that a number of peers entered into an agreement with the king over feudal incidents. Whilst it is of course possible, this is not evidence that the two are directly correlated. Indeed, when the contents of the two are considered side by side, it appears far more persuasive that they were not linked at all. The avoidance of incidents was not, as in the Damna Usum, merely downplayed in the 1529 draft. It is simply not there. The 1529 draft contained a number of extremely ambitious and radical proposals, in some way foreshadowing the registration title reforms of 1925, but none that can be directly connected to the agreement with the peers. It's far more likely that rather than being a bill designed to address loss of feudal revenue caused by feckless to uses, the bill was in fact aimed at simplifying landholding and family settlements more generally. Rather than being an earlier version of what became the Statute of Uses, the idea in the 1529 bill were in fact most likely an earlier version of what became the Statute of Enrolments. The connection between the draft bill and the Statute of Enrolments, particularly the requirement for registration with common pleas, is striking. This is a point that I will address in more detail shortly when looking at the eventual passage of the Statute of Enrolments, but for now we return to the agreement with the peers. The agreement with the peers can be summarised as being framed by Prerogativa Regis and the Statute of Marlborough, and as strengthening, and indeed extending, the provisions of 4 Henry VII, chapter 17. The agreement consisted of 23 clauses, with the main provisions contained in clauses 1 to 5. Clauses 1 and 2 echoed prerogativa regis in outlining the king's prerogative right to wardship. Clauses 3, 4 and 5 contained provisions which limited to 2/3 the amount of military tenure land that could be devised by last will, leaving the king with wardship of 1/3. The editor of Letters and Papers calendared the draft immediately before the Lords' Agreement and prescribed a date of 1529 to both. This was followed by Holdsworth, but it was likely to reflect no more than the date for the beginning of the Reformation Parliament. For the draft bill, a date of 1529 seems plausible, and it has been used here. But for a number of reasons, it is unconvincing for the agreement with the peers. Of the peers who signed the agreement, 5 were ennobled in December 1529, after Parliament had been summoned: Barons Bray, Burr, Hussey, Wentworth and Windsor. Indeed, of those 5, 3 had sat in the Commons at the opening in August. The first session concluded on the 17th of December, and with only a very short window following their ennoblement for the agreement to be made before the end of the year, it seems unlikely that it can be dated to 1529. The question of the date of the agreement with the peers is further complicated by the presence of 2 other signatories, Thomas Grey, Marquess of Dorset, and Edward Stanley, Earl of Derby. The negotiations with the peers must have begun, and indeed have been at an advanced stage, by 10th of October 1530, the date of Dorset's death. It is possible that the ambitious proposal of the 1529 bill received a cold reception in Parliament, and at the end of the first session, the Crown changed tack. It is possible that this change in approach can be connected to the rise of Cromwell, whose influence was limited in 1529, but was substantial in the early 1530s. In addition, the negotiations are very unlikely to have been concluded before the 24th of January 1531, when Derby, following his maturity, sued his livery and entered upon his inheritance. The Earl's date of birth is uncertain, but is most likely late 1509 or 1510, which would make him around 21 in January 1531. It's possible that the king allowed Stanley to enter into his inheritance early on condition of the agreement. The agreement with the peers must have been concluded before the 18th of March 1532, when the king refers to it when lamenting his apparent lack of progress with the Commons. It seems most likely that negotiations between the king and the peers were concluded, therefore, between January 1531 and March 1532, taking place between the first and second sessions of Parliament. The second session was held between the 16th of January and the 31st of March 1531, and the third from the 15th of January to the 28th of March 1532. Hall made no reference to the bill being presented in the second session, and the bill concerning wards and primate season was almost certainly the one drafted by Cromwell in preparation for the third session, as we've noted, and it was distinct from the 1529 bill. We can see from this change of policy, we can see this change in policy from the 1529 bill and the inclusion of both Dorset and Derby in the later agreements, that there was likely a substantial period for negotiation at the end of the first session of Parliament in December 1529 to at least January 1531. It seems probable that a similar period of negotiations also began with the Commons around the same time, but that this continued up to March 1532, when they eventually rejected the King's proposals contained in Cromwell's 1532 draft bill. The Spanish ambassador Eustace Chapuis reported to the Emperor in March 1531 that the Parliament continues but has done nothing, as I am told, and it is supposed that the King keeps it sitting for some mysterious purpose. It's possible that this mysterious purpose was the attempt to convince the Commons to support the reform that the King had already agreed with the peers in the second session. In a letter dated 30th January 1532, Chapuis reported on parliamentary discussions concerning feudal incidents, which suggests that the negotiations continued into the third session. In a subsequent letter to the Emperor on the 14th of February 1532, Chapuis wrote that the King was seeking to obtain 1/3 of feudal property. This corresponds with the agreement for 1/3 with the peers, and the date fits with the Commons' subsequent rejection of the proposal on the 18th of March 1532, reported by Hall. However, in other regards, Hall's account appears, at least initially, somewhat difficult to reconcile with Chapuis. Following on from his recounting of Henry's speech to the Commons, Hall's explanation for why the king was so angered focused on the negotiations. According to Hall, the king's initial proposal was for only half of military tenure land to be divisable by last will, as opposed to 2/3 in the agreement with the peers and outlined by Shackris. He then goes on to declare that the Commons erred in either not accepting his proposal, or at least not pushing back against the king to negotiating down to 1/3 or 1/4, which offer Hall was credibly informed the king would have taken. As a lawyer and a member of Parliament, we can expect Hall to have had a degree of accuracy and to speak with a degree of accuracy and authority. Thus, in the case of a discrepancy, it's tempting to defer to him. This is the approach adopted by Bean, who suggested that the agreement with the peers in early 1531, the king had then increased his demands from 1/3 to the half reported by Hall. To support this, Bean goes on to assert that Hall reporting Henry as having stated that all the lords have set their hands to the book is evidence that there is in fact a second agreement with the peers for 1/2. This is rather tenuous and not an especially convincing reading of the evidence. As Imperial Ambassador, Shackris had good access to information and was writing contemporaneously. His accuracy is too readily dismissed by Bean. Whilst Hall had even better information, he was very possibly in the room throughout, he was likely writing much later. The first edition of his chronicle, up to 1532, was not printed until 1548, a year after his death, followed by a revised edition published in 1550, completing the final years of Henry VIII's reign based on Hall's notes. This could suggest that Hall was writing up to his death in 1547, around 15 years after the events discussed. The most plausible explanation appears to be that rather than increasing his demands after the agreement with the peers, there was a significant period of negotiation, first with the peers and then with the Commons, in which Henry started at half and was negotiated down to 1/3, which the Commons rejected on the 18th of March 1532. The accounts of Hall and Shackris can be reconciled with this. It is more probable that Hall, who was likely writing a decade later, misremembered the order of the king's proposals than Shackris, writing contemporaneously, was wrong in February 1532. Indeed, the king's proposals for a half may have been the mysterious purpose Shackris reported the king as keeping the Commons sitting in the second session. Following the failed attempt to pass his Bill of Wardship and Primacy in 1532, Henry threatened to seek out the extremity of the law. The first peer to die having enfeoffed their fees to perform his will following the rejection of the bill was Thomas Fiennes, Baron Dacre of the South, and Dacre's case was to be the king's test case and was heard between 1533 and 1535. At this point, we need only note that following the exertion of significant pressure on behalf of the Crown, the king prevailed in Dacre's case, and it was held that users of freehold land were incapable of being devised by will. The king's threats had been realised beyond the Commons' worst possible imaginings. Looking back to the late 15th century, from 1502, Sergeant Frowick famously remarked that the greater part of the land in England was confidence upon confidence. There is no evidence to suggest that the situation had much changed by 1535. As a declaration of the existing law, the effect of the decision in Dacre's case shook English landholding to its core. Not only were future wills devising land declared to be invalid, but any title that was traced through a will at any point in the past was now vulnerable. The situation was untenable, and legislation was required. The only real question was how the Crown would approach a remedy. Following Dacre's case, the Commons' position was weak, and the king was able to impose his legislative will. Documents have survived, which give us an interesting insight into the Crown's thinking in the immediate lead-up to the passage of the Statute of Uses. As well as the final act itself, 3 earlier drafts have survived, enabling us to trace the development of the Crown's thinking in light of the decision in Dacre's case. And on the slide, these are the final 3. So I have the draft bill, which is the instructions to chronologize all we have, and then the 3 remaining are the final 3 just on the slide there. So to this end, the draft of the Statute of Uses appear to demonstrate that 2 approaches were considered by the drafters. The first proposed a scheme which was to treat the use as a common law device for landholding and to apply common law rules for legal title to uses. The second draft was the prototype to the eventual statute of uses and annexed the legal estate to the use. The third and final draft was very much the same as the second in terms of content, but it was in a more formal and parliamentary style. Indeed, it was almost identical to the eventual statute of uses itself. The first draft was clearly an early version, and it is more concise than the later drafts. It is without the style or character expected of a formal bill, but it is nonetheless very interesting and informative. The comparatively short document begins by declaring that the common law had been subverted by uses. The text then moves to outline several scenarios, such as attainders and tendency by courtesy, in which the common law was being effectively overridden by uses. The remedy proposed, as noted, was in effect to apply the common law of real property to uses. Whilst this was described by Holdsworth as applying the rules of legal title to equitable title, it's perhaps a little premature to speak of equitable title rather than the use at this point. In effect, Holdsworth viewed the draft as a scheme put forward by landholders that was useless, or almost useless, to the king. This reasoning was followed by Lemberg, who argued that whilst it was beneficial to common lawyers, it was not very advantageous to the Crown financially. The central point to this argument is that, with particular reference to paragraph 4, the draft did not prevent the devise of land by last will. In addressing this point, Bean argued that it was in fact a misreading of the text, while certainly clumsy, and indeed rather convoluted. The effect of the provision was to treat Setkius as if he had been in possession at common law, which, as Bean noted, would include preventing the devise of land by last will. As Baker notes, the bill sought to enact, in effect, an extension of the provision in 4 Henry VII, chapter 17, which treated the heir of Setkius who died intestate as if his ancestor had died seized. That the provisions in the draft bill were wider than simply being directed at revenue is clear, to which Bean argued that a scheme directed at incidents would have been difficult to enforce. Whilst this does make some sense, there were undoubtedly difficulties around enforcement. There is a more convincing explanation for the more limited nature of this initial draft. The analysis of Holdsworth and Bean of the drafts of the statute of uses do not give requisite attention to the respective immediate political and indeed legal backgrounds to the drafts. It was presupposed that the initial draft, like the later drafts to which it is compared, was prepared after the decision in Dacre's case. However, this is almost certainly not the case. If the decision in Dacre's case was as fundamental and substantively damaging to security of title as it appears to have been, then the Commons would have been in no position to object to anything Henry's government put forward. There was no need in 1535-36 for subtle negotiation or compromise. Following Dacre's case, the Commons had lost. It is much more likely that the initial draft can be dated to the period before the decision in Dacre's case, which is why I subscribe a date of around 1534 to it. An autumn 1534 memoranda for Thomas Cromwell includes an item providing for some reasonable way to be devised for the King's wards and private season. In late 1534, although the litigation has started, the outcome in Dacre's case was far from certain. It is likely that, alongside the ongoing litigation, Cromwell, under substantial pressure from the King, was actively seeking a solution in Parliament. By dating the initial draft of 1534, that is to say, between the rejection of the 1532 Bill of the Private Season and the 1535 decision in Dacre's case, it can be better understood. With this in mind, it's not surprising that the initial draft has been seen as being more beneficial to landholders than to the King. As a means of protecting the King's financial interests, this initial, less thoroughgoing draft was inherently inferior to the later, more complete statute of uses. It is possible that the importance of the broader issues around uses, particularly uncertainty of title, and the need to reconcile uses with the common law of real property, have been understated at the expense of revenue questions. However, in this instance, it seems that Cromwell sought to highlight more general issues relating to uses in an attempt, if necessary, to negotiate an even more limited bill through the Commons, even more limited than the 1532 bill letters. This understanding of the bill is further supported by the fact that it was clearly an early draft, and was not, an early draft that was not in the more complete and formal style of the later bills. In the draft, Cromwell had sought compromise, but following the decision in Dacre's case, the time for negotiation was over. Turning to the text of the final Statute of Uses itself, Clause 1 contains the main provision. Although written in the rather convoluted style of the period, in essence, Clause 1 was in fact remarkably simple. Legal estate was to be annexed to the use. Where previously, following affectment fair fees to the use of Setica use, the fair fees would stand seized, with Setica use merely having the use of the land, by operation of the Statute of Uses, following such affectment, legal title would cease to be vested in the fair fees and would automatically vest in Setica use. When A had infeed B to the use of C, following the Statute of Uses, C would not only have the use, but would also stand seized. This likewise applied in the form of a resulting use, where A had infeed B for no express use nor consideration. This was understood to be to the use of A, who was now seized. In the months following the Statute of Uses, it was read on by John Boys at Gray's Inn in 1536, who described the statute as an abolition of uses. We also see the statute explained by Sergeant Montague as extinguishing uses, and the same terminology is used by Robert Caitlin in his 47 reading of the Middle Temple. Whilst extinguishing the use is certainly more sophisticated than abolition, the essence is very much the same. Within 20 years, we see a more technical description emerge centering on uniting the use with possession, which is closer to the later phrasing of executing the use. Notwithstanding legal technicalities, the intent of the Statute of Uses was clear. By reuniting the use with the legal estate, feudal incidents would be restored. Should have put page numbers. The scheme enacted by the Statute of Uses was a simple one, and quite likely demonstrative of Cromwell's pragmatism. By attaching legal title to the use once more, the common law of real property would be restored, and feudal incident protected. There were a number of consequences of the statute, some of which were foreseen by the drafters, and others which were not. The common law of rule preventing the devise of land by last will would no longer be subverted by uses, and was restored, or perhaps more accurately, a means of evading it was removed. An exception to the rule in Dacre's case was made for the wills of those dying before the 1st of May 1536, thus remedying the uncertainty caused to existing titles by the decision in that case. A further issue recognised by the drafters was the effect of the statute on dower and jointure. The statute also affected the execution of non-express uses. Indeed, it is probable that the statute was primarily aimed at resulting uses. Following the Statute of Uses, the execution of the use in such a case would see not merely the use, but also legal title result back to the fairful, who would therefore stand seized, as noted already. Furthermore, implied uses that arose to the benefit of the purchaser on a bargain and sale would also have been executed by the Statute of Uses. This would have caused significant difficulties for conveyancers, as it was common practice when purchasing land, first to complete a contract for sale, before then making inquiries and taking advice before completing the transfer. Following the Statute of Uses, an implied use in favour of the purchaser under a bargain and sale would be executed, and the purchaser would stand seized by virtue of the statute, thus removing the time to make inquiries. The issue was addressed by the passing of the Statute of Enrolments later in the second session. The Statute of Enrolments has long been recognised as part of the same scheme of the Statute of Uses. Indeed, Francis Bacon, in his 1600 reading, stated it was but a proviso to the Statute of Uses. For Lemberg, the Statute of Uses was aimed at the uncertainty caused by secret conveyances to uses, and referred to in the Statute of Uses that purchasers faced with regards to titles. However, this appears to have been based on a misunderstanding of these secret conveyances. The reference to secret conveyances in the Statute of Uses was almost certainly to the employment of resulting uses, which were executed by the Statute of Uses and not uses implied by bargain and sale, which were the concern of the Statute of Enrolments. In fact, the Statute of Enrolments was passed to rectify the unforeseen issues arising from the execution of implied uses, that is to say, the collapsing of contract into conveyance. Like the Statute of Uses itself, we are assisted in understanding the origins of the Statute of Enrolments by the survival of an earlier draft bill. Thanks, Jack.
Yes, of course.
I've included the 1529 one there as well, as I noted at the beginning. I argued that's much more like the Statute of Enrolments than the Statute of Uses, but the draft bill I'm referring to now is the second one, around circa 1535. So the draft bill is a great deal more ambitious and sophisticated than that which was eventually passed. An initial point to make is that the draft bill is far longer than the eventual Statute of Enrolments. In addition, unlike the statute itself, the draft contains a broad preamble in the conventional style, which was then followed by a series of technical enactments and administrative provisions. Following the preamble, the substance of the draft begins by providing that after the last day of July 1536, the use of any lands, tenements and hereditaments should not pass unless agreed in writing, made under seal and enrolled. The remaining clauses outline a series of administrative reforms, empowering the king to appoint officers in each shire who would be responsible for recording and entering the same writing within 40 days onto a roll to be deposited in the chancery, which could be inspected by interested parties. The content of the draft bill, particularly the first clause, is interesting. The draft speaks of declared uses, proposing that all uses would be invalid unless they were declared in writing and enrolled. That is to say, it applied to express uses and resulting uses arising from refectment or other form of conveyance for no express use or no consideration, but not implied uses. The statute of enrolments that was eventually entered was both far more limited and addressed only uses arising impliedly from bargain for sales. The inclusion of other uses in the draft bill and not the eventual act itself may explain the apparent confusion for Lemberg, who argued the statute of enrolments was specifically addressed to secret conveyances. That the draft gives a date of the end of July 1536, after which uses were to be invalid unless they were in sealed writing and enrolled, is interesting, in that it appears to demonstrate that the draft was prepared late in the Reformation Parliament. The 7th session of Parliament ended on the 14th of April 1536, so the draft must have been completed before then, and indeed completed with time to change tack and pass the subsequent statute of enrolments. It is unlikely that the draft July date was proposed to allow time to implement the administrative bureaucracy that the king was empowered to establish. The scale of this proposal was substantial, which suggests a date far in advance of the end of Parliament end of parliamentary session in April. The Statute of Uses itself was enacted to take effect from the 1st of May 1536. Although the draft of the Statute of Enrolments would have taken effect, had it been enacted, almost 3 months after the Statute of Uses, it appears unlikely that it was prepared after the Statute of Uses. As has been seen, the most likely explanation for the later draft of the Statute of Enrolments was to allow time, was to allow time for the administrative bureaucracy to be established. That the draft required the enrolment of all declared uses appears to suggest a number of things in relation to the drafting of the Statute of Uses. In requiring the enrolment of all uses, the draft bears a striking similarity to the 1529 draft bill. The earlier 1529 draft was quickly rejected in favour of a more direct approach, focused on feudal incidents, but it may be that those who prepared it continued to propose a much broader reform to the law of real property, and that the draft of the Statute of Enrolments was prepared by the same drafters. With regards to the draft's purpose and its relationship to the Statute of Uses, 2 alternative explanations can be suggested. Firstly, that it was an alternative to the Statute of Uses, in which, rather than attaching legal title to the use, the Crown would seek to protect itself from loss of revenue by requiring all the declared uses to be enrolled. As we have noted above, in relation to the 1529 bill, it's possible that this would, to an extent, have provided a greater protection to the Crown from loss of feudal incidents, but this would have been limited. If the draft was prepared before the decision in Dacre's case, this understanding of the draft for the Statute of Enrolments may be more plausible, as a creative means of providing some protection to the Crown, but it seems unlikely. A more probable explanation for the draft is that it was prepared alongside the Statute of Uses, and was intended to apply to those uses of land which were not caught by the Statute of Uses, that is to say, uses of non-freehold land and those with active duties. This could therefore represent a more holistic reform to the law of uses more generally, and one which sought to reconcile uses with the broader law of real property. However, it is unlikely that as a result of the practical and administrative difficulties, it was ultimately not pursued. Sorry, it is likely. only for the idea of enrolment to be quickly resurrected following the realisation of the effect of the statute of uses on implied uses. As we've seen, the passage of the statute of uses through the Reformation Parliament was a complicated one. In this paper, we've considered 6 identifiable drafts and the agreement with the peers in the 1529 Bill, the 1532 agreement with the peers, the 1532 Bill of Wardship and Prima Season, the 1534 Bill, the incomplete draft of the statute of uses, and the final draft of the statute of uses, and this draft of the statute of enrolments. Notwithstanding these difficulties, the eventual scheme that was passed enacted what was thought to be a rather simplistic measure to address both the fundamental question of the relationship of uses with the common law of real property and the avoidance of feudal incidents. However, by executing uses that arose impliedly in a bargain and sale, the scheme enacted in the statute of uses had the effect of removing the breathing space between contract and conveyance, which had previously allowed purchasers to carry out inquiries and take advice, and it appears that the drafters did not recognise this problem until a relatively late stage. The eventual statute of enrolments is perhaps best understood as a hasty reassembling of the initial draft for the statute, but with a far more limited scope directed solely at implied uses. The statute of enrolments is short and contained no preamble. It provided that no estate or inheritance or freehold would pass by virtue only of a bargain and sale, unless the bargain and sale was indented, sealed, and enrolled within 6 months at a court of record in Westminster or in the county in which the land was situated. When in 1532 the Commons rejected Henry's proposed Bill of Wardship and Prima Season, as we've noted, Hall reported, the King threatened the Commons that he would search out the extremity of the law. The King was as good as his word, and following the decision in Dacre's case, the Commons were forced to capitulate. However, this was far from the end, and Henry's complete victory was short-lived. A mere 4 years later, Parliament passed the Statute of Wills, which contained the same terms that had initially been rejected by the Commons in 1532. Wills of freehold land were to be valid, but only for 2/3 of the testator's military tenure land. The Statute of Uses, as I have remarked, hold the distinction of being one of very few statutes that fomented an armed rebellion. Indeed, the most serious rebellion that Henry VIII faced, the Pilgrimage of Grace, 1536, which began very proudly in my own home county, Lincolnshire, and was, as I was particularly proud to discover, one which led Henry to describe Lincolnshire as one of the most brute and beastly shires of the whole realm. I can proudly confirm not much has changed. Although by no means the prime motivation in what was predominantly a religious uprising, the complaint that landholders were no longer able to declare wills featured in the rebels' grievances. The traditional explanation has been that the Statute of Wills was passed as a result of the unpopularity of the Statute of Uses, but the response of the King in dismissing the rebels as base and rude commons who ought not to be concerned with the statute appears to suggest that the reasons for Henry's subsequent compromise were more subtle than has been supposed. Indeed, a more compelling explanation has been advanced more recently by Professor Baker. One of the ringleaders of the Pilgrimage of Grace was Robert Aske, a Gray's Inn barrister, and he was... Gray's Inn,
Yes,
but
that wasn't me.
Another northerner barrister, and he was particularly concerned that landholders should be able to devise part of their land by will. Indeed, he went as far as to threaten the King that lawyers would exploit the loopholes in the Statute of Uses, of which, he warned, they were already aware. The claim made by Aske was not taken lightly. Following his arrest, ascertaining what these loopholes were formed a substantial part of his interrogation. As Baker notes, it appears that the drafters of the Statute of Uses gave little thought to future or contingent interests in use. That the statute was directed at uses which, in the manner of the Statute of Marlborough and 4 Henry VII, Chapter 17, affected the avoidance of incidents is clear. However, in our period, uses were employed for a far wider range of purposes, and increasingly experimental purposes. The simplest form of the device envisaged by Aske appears to have been a conveyance for term of life with remainder over to the intended heir. As the heir would take the land by remainder and not by inheritance, incidents would be avoided. There is evidence that more sophisticated versions may have been in the mind of contemporary lawyers. A greater flexibility than a vested remainder could potentially be obtained if the remainder was to a person to be appointed by will, such a device was contemplated before the Statute of Uses, and there is also evidence of more innovative settlements with powers of appointments, shifting uses, springing uses, and perpetuities. As Baker notes, by 1539, Cromwell was sufficiently concerned about loopholes that he sought the advice of the judges. It is perhaps that it was this concern, initially raised by Aske, about the limitations of and potential loopholes in the Statute of Uses that led to the King's most blessed disposition and liberality, quite the change of tone, with the passing of the Statute of Wills in 1540. The whole episode around Aske's interrogation is particularly interesting in what it tells us about the passage of the Statute of Uses. That a device somewhat similar to what became a strict settlement caused such concern, notwithstanding that it was apparently known before the Statute of Uses, appears to support the suggestion that the scheme enacted by the Statute of Uses was devised at a late stage and focused with an almost blinkered pragmatism on the avoidance of incidents. This is apparent in the rejection of the earlier drafts, particularly the first draft of the Statute of Uses, which can be dated to 1534, and by its limitations appears to have been a compromise in the event that the Crown was unsuccessful in Dacre's case, and the subsequent issue with the execution of uses implied into bargains and sales that was remedied at a very late stage by the Statute of Enrolments. Furthermore, Aske's interrogation is also interesting in what it tells us about what was not in his consideration. It is well known that devices emerged in the later 16th century that got around the Statute of Uses, notably the use upon a use. Although Aske stated that following the Statute of Uses there were more ways than before to effect a power to devise land, this was almost certainly a reference to the more complicated devices centred on remainders. It is possible that a conveyance of freehold land in the form of a use upon a use was in the mind of the conveyancers before the Statute of Uses. However, that is not to say that it was in the mind of the drafters. If the final version of the Statute of Uses failed to consider the execution of implied uses into bargains and sales, as well as the possibility of life estates followed by remainders not being caught, it is almost certain that the use upon a use was not a deliberate omission. Indeed, the language of the Statute of Uses clearly suggests that it was better understood as a pragmatic attempt to address an apparently simple problem, that of Feffnance to the use of the last will, with a simple solution. Uses that arose, I quote from the statute, by any manner or means whatsoever, would be executed in every such case. The apparent simplicity of the statute and its unanticipated limitations, when seen alongside the rejection of the earlier, more ambitious and complex drafts, is perhaps best understood as a statutory monument to Cromwell's pragmatism. And I think from this, a number of, I suppose, slight conclusions can be drawn. I've drawn a few of them together kind of at the end there, that I think the eventual scheme in the Statute of Uses was derived quite late on. I think that that's clear. And I think a particular avenue of interest to me, the historian, I suppose, more than the lawyer.
Sorry, I think I'm like
The historian in me, I suppose, more than the lawyer. Drafted the statute. And very much falls into this Eltonian idea of, is Cromwell this great mastermind who's doing everything? I quite like Starkey's reaction to this, where he asked Elton, at which point do you think Thomas Cromwell told Henry he was no longer needed? And I think that this, I look at this and going through these drafts and see a very pragmatic fixer rather than a grand mastermind in Cromwell. Thank you very much.
Well, thank you so very much, Ashley. That was absolutely fantastic. I will disconnect this so people don't have to see their own faces when asking questions. Fantastic.
But now I can't see.
Oh, yes. Well, that is true. I can bring this around. Well, anyways, thank you. That was extremely well prepared, well reasoned, and an absolutely fantastic seminar. I'm personally a bit out of my depth here in terms of subject matter, but I would start out with perhaps not too terrible of a question. Well, I suppose I shouldn't preface it with that. Was there any indication from the Dacre case that you were discussing that the proceedings might have influenced the kind of contemporaneous decision-making on the formation of these statute drafts in regards to how it might be decided or how the perception that it might be decided would be?
Firstly, it's about King Henry, so you should be very familiar. Just the wrong Henry.
Just the wrong. Yes. If only it were that easy.
Sorry, so
Sure.
is there a perception in Dacre's case that you want to say the influence of Dacre's case on?
Sure, while it was still being decided, essentially, because they were parallel, if I understand this correctly.
Yeah.
Was there any indication then that perceptions of how the Dacre case was progressing, excuse me, can't even talk today, or just kind of the context behind it might have evolved the thinking?
That's interesting, and I think that might be what's going on in 1534. I think Cromwell is somewhat panicking in 1534, which is why we've lost the PowerPoint.
Sorry.
The 1534 draft is terrible. It does very, very little. And I think Cromwell is just looking for any win with the 15th. He's like, I need to get something through. I've told the king I'm going to get some bill through. I need something. And he's just looking for a win. And that's interesting with regards to the deliberations in Dacre's case. As many will know, there's the very interesting report from Spellman on the discussions with the judges in Dacre's case, that initially they're split evenly, well, depending on how the report's heard correctly. And then there's I think, quite a lot of pressure on the judges. So it might be that that decision, we're not quite sure where it's going, and I think that might be in terms of, I think that's pretty well known, but the 34 draft, if I am right in saying it was 34 rather than later, and it's before Dacre's case, then yeah, I think that's exactly what's going on.
Thank you.
Active uses are clearly not covered by the statute as drafted. So why, the day after the statute came into effect, doesn't some clever conveyancer just put in an active duty there so as not to execute the use and hence have a will?
To answer that question, I think I require far more looking at deeds and to see how prevalent they actually are, and how, because I think that's interesting, and I think that the devices emerging around after, and I just don't think they're paying. It's so the draft. It's not in the mind of the drafter. It might be in the mind of clever lawyers, but then how often is it going to?
Well, no, I think the point is that it's clearly not in the mind of the drafter. Yeah. But you don't have to be a very clever lawyer to see it. I think it takes about 10 seconds if you're a moderately clever lawyer to see you can just try and coach and fall through the statute by putting in an active duty. And clearly the evidence is that that's not happening in later 1536. And the only explanation I can see for that is that Dacre's case is still effectively the root of the no devise of land. So whatever mechanism you're using to devise land, even if it looks okay on the surface, ain't going to work. But that's the effect of Dacre's case rather than the effect of the statute.
And the retrospect, so yeah, because the provision in the statute only deals with the retrospectivity of will, so the effect of Dacre. Yeah, okay, that's interesting. I hadn't thought of that. I'll quickly change that before the no, that's interesting. Yeah, I haven't particularly thought of that in enough detail.
And if I can have another question.
Yes, of course.
One I'll try and deal with better.
Well, no, it's in front of you. It is curious that there's very little focus on stockage. But all the focus that we're getting is on military tenure, except when we're dealing with the power of devise, which clearly does operate in both Dacre's case and in the statute of uses. That will operate on stockage land as well. And I have absolutely no idea of how much land is sockage land and how much. But it does seem curious that we're getting almost these two separate issues. And I think this is part of what you're saying, that we're getting that you can't leave land by will. And there's this whole problem of the way the uses are subverting the common law. People are using this mechanism to get around fundamental common law rules. That's wicked. And then there's the separate story, the financial side of fiscal issues. And that, of course, is only concerned with military tenure.
And, well, with prerogative lordship, interestingly, perhaps not, depending on, so Stoner's case, 1495 was a big debate as to whether, if there's an uncertainty with regards to whether it's sockage or whether it's, then it's the presumption is in favour of the king, and even if there's a little bit of night service, or if there's a little bit of uncertain land, then it can get off. So, but yeah, but with regards to whether, it is interesting. I think we often, just the sole focus with uses perhaps being a bit too heavily on incidents. And I do kind of think that's the case. We don't really think about sockage land an awful lot, and probably should a bit more. Sounds like a problem for me. Something to do.
We need to look at all the conveyances between 1536 and let's say 1560. Just go to every record office.
Yeah, exactly. How many lifetimes do I have? Thanks, Eddie.
Do we have any other questions in the room before we?
Yeah, well, this is an ignorant social historian type question, predictably. But I guess it follows on, I suppose, from David's points about, how numerous are uses of all kinds by this date. I'm just trying to think about the different social groups that have got a stake in these discussions. And it could be that the statute is really about a subset of a larger category of uses, perhaps. I mean, are all uses attracting feudal incidents? Are they all involving what the medievalists might call tenants in chief? Or is there a bigger category that are of less interest because they don't have that fiscal dimension as well? So this sort of follows. I mean, how large a corpus? I mean, this is clearly what you're arguing is that these are important, being used for lots of different reasons. That's perhaps why in the 1520s it's becoming an increasing issue. But it's sort of sense of the scale of the issue.
Well, Joseph Biancalana argues that after Tartarin's case, which makes the breaking of entails, not supposedly, makes the breaking of entails easier by means of common recovery. He's argued that that means that there's a greater extent of night service land, which is now freehold. Sorry, not it was fee simple and therefore available to be in future uses. So with that, it's perhaps increasing in terms of proportion. The only real, I suppose, point on that comes to mind immediately is the very famous line from Froelich that most of the land in England is in definite strong confidence. Whether that's true or not is a different question. But again, that requires my season ticket for the railways and going around every record office in the country. I'm not sure I quite have the lifespan for. Not quite the explanation.
There's only one way to find out, right?
The one answer, Chris, to that is that there's a thing which is very easy to forget, charitable uses, or upkeep of bridges, schools and things like that. And that's the typical active use. And those are really very common, and nobody's objecting to those at all. They're jolly good things.
Yeah. Well, I suppose that feeds into one of the broader points that I try and bring out is I think that not in this paper, but more generally, is so this Marlborough almost dichotomy, I think, comes probably from Marlborough, is I think there's a dichotomy running through between bona fide uses and mala fide uses, for the better way of saying it. And I think that those would be considered fine to for the bridge and for the school and for the charity, whereas to avoid paying the king's taxes, well, in incidents, obviously bad business. I think that's probably what's going on there.
I've noticed we do have one online. Do we have any other in the room before we make our transition? Okay, perfect. Helen, if you don't mind, please go ahead and turn your microphone, and if you'd like your camera on, I can't promise it'll come through. Got it.
Hi, I'm sorry that I'm joining from somewhere a bit noisy. Hi, can you hear me okay? Oh, thank you. Well, firstly, thank you, Ashley, for a really fascinating talk. It was brilliant. I very much enjoyed it. I was struck by your point about it being premature in this period when you talk about equitable title, or even kind of predecessor concept of that. Do you think that these kind of huge legal earthquakes, in the end, sort of accelerated the process to something that concrete, or do you think they slowed it down, as that was a development that was sort of gradually evolving? What do you think about that?
Statute of uses itself. Problem. That's a really good question, and one which requires so ignoring the statute of uses, and let's pretend that my work stopped in 1529, as was initially thought, before David very unhelpfully suggested that I carry on, and then come and run into these problems. But so I argue that a lot of the earlier legislation does. So quite notably, the statute 1 to the 3rd chapter 1, which gave effectively the beneficiary of a trust the right to convey a legal title. So I'd certainly say that sped it up, and that almost crystallized, and this is something I argue as well, almost kind of crystallizes something that was there, and we're getting closer to an idea of beneficial ownership. The statute of uses sort of blows that aspect up somewhat, I think, by effectively removing in these situations, those particular situations of uses to perform last wills. But then in another way, it's from the exceptions to the statute of uses that we've been kind of talking about, the active uses and things like that, and uses of non-freehold land that develop into the modern trust. So whether it sped it up or slowed it down, I don't know. It's certainly a turning point.
Thank you very much.
Did we have any additional questions from our online attendees? Well, then I'll just open it up in general in the room, online, last call. Any questions, comments, concerns, anything with that fantastic seminar? In that case, I will thank Ashley again very, very much for coming down and presenting this wonderful talk to us. And we have some thank yous coming in online as well. This will be recorded and placed on our YouTube channel for future viewing. And I know some people have expressed an interest in doing so already. And then our next seminar, I will go ahead and announce, is going to be, make sure I have this correctly. Yes, the 1st of June with now Dr. Stephanie Brown with a discussion on 14th century Yorkshire and criminal law, making a medieval murderer, identity and prosecution in 14th century Yorkshire. So we hope to see you all then, and thank you so much again. Do a little another round of applause. Fantastic.